He walked out of that courtroom a free man. And before the doors had even swung shut behind him, the world had already decided the justice system had failed. Thousands of people who had watched every hour of that trial on their phones and laptops, people who had debated every witness, every piece of testimony, every attorney objection in real time, were furious. Comment sections erupted. News networks scrambled their legal analysts. Social media became a courtroom of its own, and in that courtroom, the verdict was unanimous. The jury had gotten it wrong. The system had broken down. Justice, people said, was dead. But here is what almost nobody stopped to ask in the days and weeks that followed. What if the jury didn't get it wrong? What if 12 ordinary Americans who sat in that room for weeks, who heard testimony the cameras never captured, who listened to evidence the commentary never fully explained, who took an oath that the social media audience never had to take? What if they saw something that the critics, for all their passion and certainty, simply missed? That is the question this story is going to answer. Not because the verdict was comfortable, not because the outcome was emotionally satisfying, but because understanding what actually happened inside that courtroom, understanding the machinery of American law, the strategy of the legal teams, the psychology of the people involved, and the cold precision of the evidentiary standard that governs every criminal trial in this country, is the only honest way to look at this case. And honestly, it changes everything. To understand where this case ended, you have to understand where it began. And it began, like so many cases that capture the public imagination, not with a single dramatic moment, but with an accumulation. A slow build of circumstances, relationships, and decisions that would eventually collapse into something no one could ignore. The investigators who first caught this case were experienced. They had worked complex matters before. They understood that the most dangerous assumption in any investigation is the assumption that you already know what happened. And yet, almost from the beginning, the narrative pressure on this case was immense. There were people, powerful, vocal, connected people, who believed they knew exactly what had occurred. And that belief, however well-intentioned, began to shape the investigation in ways that would only become visible much later inside that courtroom, under the unforgiving light of cross-examination. The prosecution's theory of the case was not unreasonable on its face. There was a defined relationship between the defendant and the circumstances of the alleged offense. There was a timeline that, if you squinted at it in a certain way, appeared to place the defendant in proximity to the events in question. There was physical evidence, or rather, there was what was described as physical evidence, that the prosecution argued connected the defendant to what had allegedly taken place. And there was motive, or at least what the prosecution characterized as motive, a history of conflict, a pattern of behavior, a set of prior circumstances that, arranged in a certain order and presented with enough conviction, could be made to look like the opening chapters of something deliberate and calculated. The prosecution had a story. It was coherent. It was emotionally resonant. It was the kind of story that, told in a press conference or a cable news segment, sounds like a closed case. But a press conference is not a courtroom, and a cable news segment is not a trial. Inside a courtroom, every single claim has to survive contact with the rules of evidence. Every piece of physical material offered to the jury has to clear a series of legal hurdles that exist specifically to ensure what the jury sees is reliable. Every witness has to submit to cross-examination, a process designed not to embarrass or destroy, but to test, to probe, to find the edges of what a person actually knows versus what they believe, versus what they have been guided toward believing. The American adversarial system is often criticized for being theatrical, for rewarding lawyers who perform well rather than arguments that are true. And that criticism has some merit. But underneath the theater, underneath the objections and the sidebars and the carefully choreographed presentation of evidence, there's a genuine intellectual structure. A framework built over centuries to answer one question as honestly as possible. Has the guilt of this person been established to a degree that no reasonable person, applying reason and not emotion, could dispute? That is the standard, beyond a reasonable doubt. You have heard those words so many times that they may have lost their weight, but let them sit for a moment. Beyond, A. Reasonable. Doubt. Not beyond all doubt, because certainty is rarely available to human beings operating in a complex world with incomplete information, but beyond reasonable doubt, doubt that a thoughtful, fair-minded person, looking at the evidence presented and applying logic rather than instinct, would find legitimate, doubt that has a basis, doubt that can be explained and defended. If that doubt exists, if any thread in the prosecution's fabric is loose enough to pull, then under the Constitution of the United States, the verdict must be not guilty, not because the defendant is necessarily innocent, but because the system demands that conviction be earned, fully, completely, without the shortcuts that emotion invites. The prosecution in this case made several decisions early on that seemed tactically sound, but would later prove to be vulnerabilities. The first was the decision to lead heavily with circumstantial evidence. Now, it is worth pausing here because there is a persistent myth in popular legal culture, largely driven by television, that circumstantial evidence is somehow lesser evidence, that it barely counts, that any defense attorney worth their retainer can wave it away with a dismissive gesture and a well-timed pause. This is not true. Courts have convicted defendants on purely circumstantial evidence in some of the most serious criminal matters in American legal history. The Supreme Court has affirmed repeatedly that circumstantial and direct evidence are entitled to equal weight. What matters is not the category of evidence. What matters is what the evidence actually proves. And the critical legal test for circumstantial evidence in a criminal trial is this. Is the inference the prosecution is asking the jury to draw the only reasonable inference available? Or could the same set of circumstances be explained in another way, a way consistent with innocence? If the answer to that second question is yes, then the circumstantial web, however densely woven, has a hole in it, and in this case, the defense found that hole. They found it, and they walked through it slowly, methodically, without drama, in a way that was devastating in its quietness. The defense strategy in this case was a lesson in restraint. In an era when criminal defense has increasingly become performance, when the cameras invite grandstanding and the public appetite rewards the dramatic, the defense team here chose a different path. They did not put on a counter-narrative full of alternative villains and conspiracy theories. They did not try to win the emotional argument. They made a deliberate, disciplined choice to fight this case on legal and evidentiary grounds alone. Their goal was not to convince the jury that their client was a saint. Their goal was to demonstrate, piece by piece, that the prosecution had not met its burden, that the evidence, examined carefully, did not add up to certainty, that there were too many questions, too many gaps, too many moments where the story the prosecution was telling required the jury to assume things that had not been proven. Every assumption is a gift to the defense. Every inference the jury has to fill in for themselves is a brick removed from the wall the prosecution is trying to build. And in this case, the wall had more missing bricks than the public ever realized. The first major crack appeared during the testimony of the forensic specialist. This witness was the prosecution's anchor, the person whose technical expertise was supposed to translate the physical evidence into something the jury could understand and trust. In a press conference setting, the testimony would have sounded authoritative and final. In a courtroom, under cross-examination, it became something else. The defense attorney began not with the conclusions, not with the dramatic stuff, but with the foundation, the chain of custody. This is a concept that sounds procedural to the point of tedium, but its importance to the integrity of a criminal trial cannot be overstated. Under the federal rules of evidence, specifically Rule 901, the prosecution must authenticate every piece of evidence it presents. They must demonstrate that the evidence is what they claim it is, that it was collected properly, documented accurately, stored under appropriate conditions, transferred through verifiable hands, and arrived in the courtroom in the same condition it was in when it was first gathered. Any break in that chain, any gap in the documentation, any period where the evidence cannot be fully accounted for, creates a question. And questions are the currency of reasonable doubt. The forensic specialist, to their credit, did not attempt to conceal what had happened. They acknowledged under oath that there had been a procedural irregularity in the handling of one of the key pieces of physical evidence. It was not dramatic. It was not a scene from a legal thriller. It was a quiet, factual admission that a specific logging procedure had not been followed during a transfer of evidence between the collection site and the laboratory. The gap in the record was narrow. The prosecution argued it was immaterial, that the evidence's integrity had not been compromised. And they may well have been right. But here is the thing about a criminal trial. And here is the thing that commentators who later savaged the jury's verdict seemed unable or unwilling to grasp. It doesn't matter whether the prosecution was probably right. It matters whether they proved it, and probably right is not the standard. The standard is beyond a reasonable doubt. That procedural gap introduced a legitimate question about whether the evidence could be fully trusted, and that question, sitting alongside the other questions the defense had carefully and methodically introduced throughout the trial, was one of the reasons 12 jurors came back with the verdict they did. The second significant moment came during the testimony of a witness the prosecution had clearly relied upon heavily in building their case theory. This individual had a relationship with the defendant, a complicated, layered, historically contentious relationship, and they testified in a manner that was, on the surface, compelling. They were articulate. They were emotional in the right moments. They conveyed conviction. And for the people watching the live stream, this testimony felt like a turning point. Here, finally, was the human piece, the narrative thread that tied everything together. But the defense had done their homework. They had spent weeks reviewing every prior statement this witness had ever made, to police, in depositions, in informal communications that had been preserved and subpoenaed. And what they found was a pattern. Not a pattern of lying, necessarily, but a pattern of inconsistency, a pattern of details that shifted slightly between accounts, a pattern of emphasis that changed depending on who was asking the questions and in what context. Under cross-examination, the defense attorney went through these inconsistencies one by one, slowly, calmly, without accusation, simply asking the witness to explain why, in an earlier statement, they had described a particular detail differently, why, in a prior account, the timeline had been characterized in a way that contradicted what they had just testified to. The witness struggled, not catastrophically, not in the way that gets replayed on television, but enough to leave a residue of uncertainty in the minds of the jurors who were watching carefully and taking notes. And this is where we have to talk about the jury. Because the jury, those 12 people who were vilified after the verdict, who were called foolish and biased and compromised by commentators who had never spoken to them, who had never sat in that room, who had never experienced what it means to be responsible for a decision of that magnitude, the jury was paying attention in ways that the public audience simply could not. They were not watching a highlight reel. They were not catching segments between commercial breaks. They were present for every single moment of that trial. They heard the testimony that never made the news cycle because it wasn't dramatic enough. They sat through the dry, detailed, unglamorous procedural arguments about evidentiary rules that determine what they were even allowed to consider. They watched the demeanor of every witness, not just in the moments the cameras found interesting, but throughout, during the long stretches of technical questioning, during the redirect examinations, during the moments when witnesses thought the most difficult part was over and their guard came down slightly. Jurors see things. They notice things. They are, by design, the fact-finders, and the American legal system, for all its imperfections, trusts them to do that job in a way that no camera and no commentator can replicate. The jury also received something the public did not: the judge's instructions. These instructions, delivered before deliberations begin, are one of the most underappreciated elements of any criminal trial. The judge does not simply tell the jury to go deliberate. The judge walks them through the law, through the specific legal definitions that apply to the charges, through the standard of proof and what it means in concrete terms, through the rules about how they are supposed to evaluate witness credibility, how they are supposed to treat circumstantial evidence versus direct evidence, how they are supposed to handle a situation where they find some witnesses more credible than others. In this case, the judge's instructions were detailed and precise. And critically, they included a clear, unambiguous statement about reasonable doubt, one that aligned with the pattern jury instructions used in federal courts across the country, which have been refined through decades of appellate review to capture exactly what that standard means. The jurors did not leave the courtroom to deliberate with a vague sense that they should vote their feelings. They left with a legal framework, a set of tools, and they used them. The deliberations lasted longer than the public expected, and that, in itself, is meaningful. Juries that deliberate for extended periods are not juries that are confused or lost. They are juries that are taking their responsibility seriously. They are going back through the evidence. They are arguing with each other. They are challenging each other's interpretations. They are doing exactly what the system asks them to do. In a culture that has become accustomed to instant resolution, to verdicts rendered in the comment section before the evidence is even fully presented, the patience of a deliberating jury is almost countercultural. But it is also arguably the most important part of the entire process, because the verdict that comes out of extended deliberation is not a reactive verdict. It is not an emotional verdict. It is a considered verdict. And considered verdicts, even ones that feel wrong to outside observers, deserve more respect than they typically receive. When the verdict came, the reaction was swift and severe. The media cycle kicked into full gear. Legal analysts, some of whom had been predicting a conviction throughout the trial, were left to explain an outcome that didn't fit the narrative they had been constructing for their audiences. And here is where something psychologically interesting happened. Rather than examining whether their analysis had been incomplete, rather than asking what information they might have missed or what aspects of the trial they had underweighted, the dominant response was to locate the failure outside themselves. The jury had been fooled. The jury had been swayed by something improper. The system had malfunctioned. This framing is deeply human. It is also, in this case, almost certainly wrong. What actually happened is something that legal scholars have a name for, and that name is the gap between legal guilt and factual guilt. Factual guilt refers to whether a person actually did what they are accused of doing. Legal guilt refers to whether that fact has been established in a court of law to the degree required by the applicable evidentiary standard. These two things are not always the same, and in a society governed by law rather than by popular sentiment, legal guilt is the only kind that can carry consequences. This is not a bug in the system. It is the central design principle of the system. It is the reason the presumption of innocence exists. It is the reason the burden of proof rests entirely with the government and not with the accused. It is the reason defense attorneys are constitutionally protected in their ability to challenge every piece of evidence the prosecution presents. Because the alternative, a system where the accused must prove their innocence, where the government's accusation carries its own presumptive weight, where the efficiency of conviction is valued over the reliability of conviction. That system has a name, too, and it is not democracy. The Sixth Amendment guarantees the right to a speedy and public trial, to an impartial jury, to be informed of the nature of the charges, to confront witnesses, and to have the assistance of counsel for the defense. The 14th Amendment extends the guarantee of due process. These are not abstract ideals. They are operational requirements that shape every moment of every criminal trial in America. And in this case, those requirements were met. The defendant had competent, prepared counsel. The evidence was subjected to rigorous examination. The jury was instructed on the law. The process worked as designed. The outcome was not what many people wanted. But wanting a different outcome is not evidence that the process failed. There is a broader lesson here that extends well beyond the specifics of this case, and it is a lesson about the relationship between public opinion and legal process in the era of media saturation. We live in a moment when access to information has never been greater, and the depth of understanding that access produces has never been shallower. We watch trials in real time, but we watch them through a frame constructed by producers and editors and commentators who have their own analytical limitations, their own narrative preferences, their own incentive structures that reward engagement and emotion over precision and nuance. The trial that the public watches is not the same trial the jury experiences. The evidence the public considers important is not necessarily the evidence that matters most under the law. The witness the public finds believable is not always the witness who holds up under cross-examination, and the verdict the public expects is not reliably the verdict the evidence actually supports. Cognitive scientists have studied what happens when people form opinions about criminal cases through media coverage, and the findings are consistent and sobering. Exposure to pre-trial publicity, to the kind of intense, sustained, emotionally charged coverage that high-profile cases generate, creates something called a narrative anchor. The brain latches onto the story it was given first. It builds a mental model of what happened. And then, when new information arrives, information that complicates or contradicts that original story, the brain does not update the model with neutral precision. It filters the new information through the model it already has. Information that confirms the original narrative is accepted easily. Information that challenges it is scrutinized more harshly, remembered less accurately, and weighted less heavily in the final judgment. This is not a character flaw. It is a feature of human cognition. But it is precisely the feature that the legal rules around jury selection, juror conduct, and deliberation are designed to counteract. Jurors in high-profile cases are instructed to avoid media coverage for exactly this reason. They are asked to decide the case on the evidence they hear in the courtroom, not on the story they have been told by the world outside it. And when jurors do that, when they actually follow those instructions, as the jurors in this case appeared to do, the verdict they reach may look very different from the one the public was expecting. Let us talk about the closing arguments, because the closing arguments in this case were illuminating in a way that got very little attention in the post-verdict coverage. The prosecution's closing was, by most accounts, emotionally powerful. It was well constructed. It returned to the theme of the case, restated the evidence in its most favorable light, and made an appeal to the jury's sense of responsibility and justice. It was the kind of closing argument that earns respect from other trial attorneys. It was designed to move people, and it probably did move people. But moving people and meeting a legal standard are different things, and the defense's closing, far less discussed, far less quoted, was designed to remind the jury of exactly that difference. The defense attorney stood at the podium and did something that, in retrospect, was strategically brilliant. They did not argue about the evidence at all. Not directly. Instead, they talked about the standard. They talked about what beyond a reasonable doubt actually means, not in the abstract, but in the specific context of this case, in relation to the specific gaps and questions and inconsistencies the defense had spent weeks introducing into the record. They walked the jury through every moment where the prosecution had asked them to assume something that hadn't been proven, every moment where the story required a leap of inference rather than a direct line of established fact. And they said, quietly but with complete precision, your job is not to decide what probably happened. Your job is to decide whether guilt has been proven, whether the doubt that exists, and they were careful not to say if, they said the doubt that exists is reasonable. And if it is, then the oath you took in the law you're sworn to apply requires one verdict, and one verdict only. The jury went back. They deliberated. And when they came back out, the verdict that they delivered, the verdict that sent the internet into convulsions, that generated headlines for weeks, that became shorthand in political conversations for everything wrong with the justice system, was not the product of confusion or failure or corruption. It was the product of people doing exactly what they were asked to do, applying the law, measuring the evidence against the standard, finding, after extended and serious deliberation, that the standard had not been met. That is not a scandal. That is the system working. The critics who missed this were not bad people. They were people who cared about the outcome, who had strong feelings about justice, who had watched the case unfold and formed sincere convictions about what should happen. But sincerity is not a substitute for understanding, and caring deeply about justice is not the same thing as understanding how justice is actually administered. There's a difference between what we want the system to produce and what the system is designed to produce. The system is designed to produce one thing above all others: reliable verdicts. Verdicts that rest on proven facts, not assumed ones. Verdicts that the government has earned through the quality of its evidence, not through the volume of its confidence. Verdicts that protect every person who might one day stand accused, including people who are genuinely innocent, by refusing to lower the bar of proof just because the accusation feels credible. What the court saw that the critics completely missed was not a technicality. It was not a loophole. It was not a failure of common sense or a manipulation of procedure. What the court saw was the evidence, measured against the law, evaluated by 12 people who had sworn to do exactly that, and found, by that measurement, against that standard, to fall short. That is a hard thing to accept when you believe the outcome should have been different. It is supposed to be a hard thing to accept. Justice is supposed to be hard. It is supposed to resist the pressure of emotion and popularity and certainty. It is supposed to ask the hardest question, not what do we believe, but what have we proven, and to answer that question honestly, even when the honest answer is uncomfortable, even when the honest answer makes people angry. Even when the honest answer feels, to those on the outside looking in, like a verdict that the truth didn't deserve. That is what happened in this case. That is what the jury understood. And that when all the noise finally clears is what the critics missed.